Hello and welcome to this presentation on the Next Gen Performance Test. My name is Professor Brett Bendistis, and this presentation is going to go over the Next Gen PT. We're going to talk about the practical closed book exam that's going to be coming to the bar exam, with a way of focusing on a few different components of what I just said. The idea that it's a closed book exam and the fact it is a practical test of your legal ability. Right. So those are the things that we're going to talk about today. We're going to go through a actual PT. We're going to talk about the different elements of it. We're going to talk about IRAC writing, rule development, all these things to give you an idea of what to expect and to where to focus your attention in particular when it comes to answering this particular assignment. What I'm going to do is I'm going to go over some PowerPoint slides that we have here. I have the exam that I'm going to go over at the very end. I'm going to show you a sample assignment just the same. I have some contact information up here that I'm going to show you a little bit later in the presentation, but for right now, I'm going to jump right into the performance test, how to think about it, and what the purpose of it ultimately is. The purpose of the performance test is to show practical legal skills. I have some points here that I want to cover here, and I want to note the idea of the practical legal skills here to me is like when you were in elementary school and middle school and math class was like, make sure you show your work. I think that when it comes to the performance test, the answer is important, but it's not the priority at the expense of showing the very particular skills that are relevant for the law. One of the things about a performance test is they want to see that your ability is, they want to see your ability to make sure that you're able to reflect good legal writing with good legal and analytical development. The big thing when it comes to legal writing is legal writing should always be in IRAC or CREAC form in an organized format. You have clear paragraphs, you have a connection between the law and the facts. Again, we're going to get through this a little bit later to make sure that it's clear. And the idea is that I want to make sure that when we cover this assignment, that you're making sure it's a mix of both law and facts to make sure that the answer is clear and it's following a really clear structure. We're also going to make sure that you're using the appropriate tone and a good legal writing form. One of the things about the PT is it's testing your ability to give legal advice. And the thing about legal advice is that the legal advice needs to convey an understanding that is both persuasive and reliable and trustworthy. One of the things about being a lawyer is that you're probably going to be dealing with, and when you think about it and think about like the cases you're reading and the type of problems that you're resolving, you're usually dealing with like a top 5 worst moment in someone's life. Right? Like, why do you hire a lawyer? Well, you hire a lawyer because like you're getting arrested or you're getting sued or you got in a car accident or like somebody passed away. And so the idea is like your tone as a legal writer isn't telling someone like, oh, well, go do this. It's making sure that person feels comfortable and understanding why they're doing the thing that you're suggesting and making sure that they know that you know what you're talking about. Now, that comes from appropriate tone, good legal writing form, and making sure that your answer is substantiated with both law and fact. So, the other thing that we're also going to talk about when it comes to practical legal development is rule development. We're going to make sure that you're writing the law in an instructive and conclusive form. You're trusting your understanding in the law that you can write it in your own words, and that you're including things like case illustrations, practical explanations of the law, and good structure to make sure that, again, your answer is connected to the facts and the law. Finally, we're going to make sure that your conclusion is based on good analysis. That when you're dealing with a problem, that your conclusion is based on why the law and the facts support that answer. We're going to make sure you're avoiding things like telling the story over again, making sure you're using the word because, all things that I'm going to go over with greater detail later. But the idea of the PT is noting the fact that if your final conclusion is what you're focusing on, you're missing a lot of the big points. The big point of the PT is that you are pretending to be a lawyer. These people are real, the problem is real, the advice you're giving is legitimate. And so I wanted to have the approach with all of this is that you're approaching it the way that a lawyer should approach a problem. Again, that's not an answer. It's an academic assignment, but it's wanting to see and emulate a lot of these circumstances that you're acting like a lawyer despite the circumstances. Now, I want to note one other thing before we get into it. The next gen performance test is going to be different than a lot of the other parts of the bar exam. I passed the bar in 2007. In 2008, I took Pennsylvania, New Jersey in 2007. I took Delaware in 2008. And we didn't have an MPT. We didn't have a performance test then. And so I'm going to make an analogy here that I've learned from kind of studying the bar exam and doing some things and working I work in the bar pass office here at the law school, which is that the interesting thing about it is just a closed memo problem, right? You probably had a closed memo at some point in legal methods. I may have been your legal methods teacher and we had a closed memo problem. But the interesting thing about this type of thing is that it is a short 60-minute time period, right? You're given a task memo, a facts section, and a law library, and you're asked to craft an example in a short period of time. Now, when it comes to the performance test, I have an analogy that I like to give. If you've heard this before, I apologize for being repetitive, but I think it is a good way to think about this particular problem. I think about this in the context of a reality show that tests professional expertise in somewhat ridiculous circumstances. Shows like MasterChef, Top Chef, Project Runway. I'll even throw Lego Masters. We're big fans of that show in the Bendistis household. But the idea is they take a skill that often takes a lot of time to be able to accomplish, and they ask you to do it in a short period of time, right? Like if you go on Chopped, you could be the greatest chef in the entire world. But if you go on Chopped, which is a reality show that tests somewhat silly cooking skills, you might lose because this is a different type of show. That's what I think about the PT, meaning that you can be the greatest writer in the entire world, right? I'm a professional writer. I love to write, right? But the idea that I can write this type of assignment in 60 minutes takes different types of skills that you have to account for, you have to practice considerably, and you have to make sure that you are appropriately using your skills for the assignment at hand. That's why this is something where again it's not the same skills as a bar exam, it's not preparing a memo. It's a little bit of both, but it takes a very particular approach that I want to share with you today to make sure you're not missing key parts. Now again, we're going to go over this. I'm going to go over all the things and show you all the assignments. But essentially, a performance test contains three elements. They contain a task memo, which is from a fake lawyer, obviously, right? Who's giving you the assignment and giving you the scope of the work that you're completing. It's essentially telling you the problem that you have to answer. It's excluding problems they don't want you to answer. And they're giving you some instructions that can help you complete the assignment in the way they want you to do it. You're also going to get a facts section. Facts section contains factual components that support the conclusion through the analysis. These are things like depositions, documentary testimony, things that you're going to use later to support your answer and support the conclusion that you're using later on. And then finally, you're getting a law library, which is a legal authority that controls the problem. It's usually going to be from a fake jurisdiction. It's usually from the law of Franklin. And your answer is limited to the law library. Let's say you know the law that covers the topic. That law is irrelevant. You are only covered what's very particularly there, meaning it's not testing your general understanding of the law. It's testing particularly your ability to answer this practical exam, right? Rule development, CREAC writing, being analytical, noting the facts. So I just want to point out the idea that your understanding of the problem is fine, but I want to make sure that you're writing for the right audience and you're including the things you need to include in the right way. Now, getting into the exam itself, this is a performance practice set that we're going to go over. I'm going to give you an answer before, but I want to go through a few points and kind of give you a good idea of what it is that you're looking at. As I mentioned before, this is your performance task memo. It includes a few very short paragraphs here. It's not a ton of information, but it's including a few points that I think is worth noting that I want to make sure that you're including, right? You're going to see some things here. Even look at this last paragraph. Draft a short memo that I may use to prepare for my meeting with Jennifer, right? That's telling you your tone, it's telling you your approach. Do not write a separate statement of facts, but be sure to incorporate the law and relevant facts and reach a reasoned conclusion. Meaning that you don't have to tell the story again. It's about analysis, it's structure, it's making sure that everything's included. You'll also see at the very beginning of the paragraph, you know who your client is, so you know what your approach is and who you're writing about. And then you're also kind of making sure that you have an idea of what the problem is. It's the validity of marriage. Okay. If I scroll down here, you'll see the facts section, which will usually include some kind of discussion from people and then some practical documents. You'll see here you have client interview notes. We'll go over this with later detail later. You have a trial transcript or an interview transcript from a neighbor. You have the certificate of marriage. You have a certificate of divorce. All right. So all that stuff's going to be relevant in there. We're going to talk what's important, what's not important a little bit later. You're finally going to have a few different sections of the law that will commonly include three different things. There's two versions of it here. There's another thing that is pretty much part and parcel with what you probably see in your classes, and it kind of is representative of the law from here. What you see here is for statutes. You're going to see a statutory section. Again, these are not real statutes, but they're usually mirrored off things that you might see in a state code, right? But it's written like statutory language. You're also going to see a few cases. Here, you're going to see two different cases. Sometimes they're a little bit longer, sometimes they're less. Sometimes you'll also see case illustrations within the decisions just the same. But I would note, like I said from the very beginning, the purpose of this is that you are writing an entire closed memo based just on this collection of information. It is closed memo. You can't use anything else than what you see here. Now, in general, when you're doing a PT, the first thing that you're going to focus on is the task memo that we talked about at the very beginning of that, the screen capture from before. I want to talk a little bit about this broadly. We're going to go back to it really quickly. I'm just going to point out a few things that I think are relevant. The task memo is something that might seem somewhat obvious, but there's a few really important things that I think you can pull out of it that I always think of as like easy points. Easy points that you can reference, easy writing structures, easy techniques that I think are worth noting, to make sure that, again, things you can practice that I think will improve things that are aside from like the substance and the analysis of the problem. The task memo is always going to cover the scope of the assignment. When I say the scope of the assignment, is that the task memo isn't something where it's cover all the issues. It's very rarely, if ever, going to give you this broad collection of material that just says address everything under the sun. It's usually something very particular. In most problems, it's telling you do this, don't do anything else. So it's important to note that just because it kind of solves the problem for yourself. If you're going to write a ton of information, you're going to waste the time that you don't really have. 60 minutes goes pretty fast. And I think that when you approach a PT, you should think about it as using all available information and just kind of covering as much as humanly possible. If you are covering things that you don't need to cover, in essence, you're taking that time away from material that you could be adding for more rule development and more application from another. So here, it's important to note very particularly when you read that memo, what am I answering and what's the scope of what I don't need to do just the same. It's also going to tell you a little bit about the format, like what's included and what's not included. In a lot of instances here, when we think about the format of the assignment, it's often going to be like memos or letters, and those are important because you want to know exactly what it is they want from you. For the multi-state test that's on the UBE and currently in Delaware, they'll have different kind of formatting answers. Or they'll be like, hey, draft a statute, draft a letter, draft an appeal. These are the kind of things that, again, with practice come time, but you also want to make sure that the format that they're asking for, that you're addressing it really particularly. If they ask for something and you give them something else, you're going to lose points regardless of the substance of your answer, because the point of the practical test is to be able to address very particular practical things. Finally, there's the tone of the assignment. And to me, it's an idea of knowing who you're writing to and then why you're writing to that person. This is so important in a lot of ways, and it's the kind of thing I want to take a little bit of extra time on just to talk about. In a lot of ways, a lot of these performance tests will ask you to either write in a persuasive or an objective tone. Now, a lot of these, they're still focused on conclusions. It's not a matter where your answer is going to be different, but the way that you address things, I think, matters when it comes to a performance test or a persuasive exam or an objective exam. Persuasive writing requires an overemphasis on conclusions and writing with confidence, meaning that when you are writing persuasively, you are right no matter what. Right. That's important for a few different reasons. In a lot of ways, what happens is that you're having to write an assignment where maybe Brett Bendistis, doesn't agree with the answer, but you still have to write like you do agree with the answer. And that can sometimes be tough a little bit, but you do still kind of have to figure it out. You know, they are commonly going to give you things where it's never like it never favors you. But again, when I go back to the MPT, a lot of the times persuasive assignments will have a few things that favor you clearly, and then one that's a little bit on the fence, and they're testing your ability to make chicken salad, if I can avoid using profanity in a presentation, right? Yeah, I'm sure you know that phrase, right? Objective writing is a little bit different. And the one we're going to go over here is more of an objective example, right? Writing a memo for a client interview is the kind of thing where you want to be candid. You want to talk about the strengths and weaknesses of both sides, and you want to write in a way that is instructive, right? But honest. In those instances, I want to note that even though you're writing objectively, you're still focusing on conclusions. In a lot of ways, I think when people write objective answers, they write it in a way where it's like, well, hey, I'm writing both sides and I'll build to my conclusion. That's not exactly what I want you to do. I want you to start, right, with the conclusion, then explain why, right? Now, problems like this usually have one clear answer that they're looking for. So believe that your answer is correct and lead with that foot forward, right? So the idea there with the persuasive and objective is, again, how much do you have to address counter arguments? How do you address those counter arguments? And what's the tone that specifically you're looking for? Another thing I want to note when it comes to tone is the idea that, there's certain style points with writing like a lawyer that are somewhat hard to get used to. But once you start getting used to it, I think it makes a lot of sense. One rule I always have is that unless it's a client letter, try to get rid of any personal pronouns. Things like we, things like our client, things like I, you don't need those. If I'm saying I think our client should win is less persuasive than our client should win. And it's even less persuasive than plaintiff should win. So the point that I want to note there is that like it takes a second, it takes a little bit to get used to it, but when you start doing it, it'll become second nature. And so that sort of language, especially when you're instructed to write things to like the court, I would never ever write I, even like he, she, they, it are just things I'm trying to get rid of to make sure that there's a clarity and a certain sense of structure that I'm following with good consistency. When it comes to sort of, the tone, I think it's a matter of the more you do PTs, the better off I think you can get at it, right? So if you're writing to a court, if you're writing to a client, if you're writing to an attorney, you want to sort of have that different mindset that, well, when I'm doing it this way, I'm going to do this. I'm going to do that way. I'm going to do that. Because I think that the more practice comes along, the better off you're going to get to it. The last thing I want to say about tone is that I think tone is mostly found in topic sentences and in the analytical sections of your writing, meaning that paragraph where you're applying the facts to the law. Topic sentences, I think, are particularly important when it comes to persuasive writing, because persuasive writing should always lead with your answer. And so the idea of, the superior court is wrong because is a great way to start every paragraph. I often have this other thing I think about when, when I'm reading really complex legal decisions, like the Supreme Court, for example. I've always found, and I'm not saying you should do this in law school, but I think practically when I think about when I'm reading it for my own interest, I've often found that like when I'm really confused by something, reading the topic sentences of the paragraphs can really give me a good roadmap of what I'm doing. Judges usually write the sentence, the explanation, the sentence, the explanation. And I want you to think about your writing just the same. When you write things like this, are you building toward the answer or are you telling me the answer and then telling me why? That second one I think is a much better structure. One, because it gives you the consistent idea of how you're writing it and make sure you're doing the same thing over and over again, but the reader understands what you're saying. Being a lawyer, in my opinion, is the kind of thing where you're only going to be able to be judged by what you can communicate to people. And if you know it, but you can't communicate it, that's not persuasive. That's not going to get you the things that you want. And so the big thing I think when we think about the different tone and the different structure is finding that consistency, finding that language that you feel comfortable with, and then using it as much as possible. Going back here really quickly, I just want to revisit this section here to note a few different things, right? So the first thing that I want to note is that again, we know that we're doing a short memo that's used for a meeting with Jennifer. That means it's objective. We don't have to argue on behalf of Jennifer because we want to make sure that the attorney that we work for is aware of what our conclusion is. That's an important component of working in a law office, knowing the strengths and weaknesses of our client's case so that we can make not only objective decisions about our representation, but we can also give our client good understanding of what like the strengths and the weaknesses of their case are. The other thing that I will also note here is, we do have a client though, and so it should be written mostly from the perspective of understanding, Jennifer can prove blank. This she'll have difficulty doing this. And so remember the fact of who your audience is. You're writing to a lawyer who's considering how to represent somebody. The more that you can incorporate that and think about the idea of like this case is good, this case is bad. Your perspective is dependent on what they're instructing you to do. So at all times when you're writing this, you're writing it from the perspective that you're really giving someone advice about what to do. You're not writing it for, a professor or an instructional, just you have to divorce yourself from the academic side of writing and think about it more as like this is a real life scenario that I'm acting out in practice. Now that we know the task memo, we know what we're doing, we know why we're doing it, we know what the tone is. Let me get to a broad suggestion that I like to do regarding the PT that's sort of focused on the idea of like the timing and the consideration of what you have to do. When I'm a lawyer and I have a problem like this and I have like all the time in the world, read the facts, right? Like read the depositions, know what the client is, know what the problem is. But again, we're on we're on MasterChef. We got to do things a little bit differently to think about the timing consideration we have so we give ourselves the right amount of time. My suggestion when it comes to the PT is like you got to do if you have half an hour, I think having a rigid application of 30 and 30, 30 minutes planning, 30 minutes writing is the best possible thing that you can do. If you want to give or take 5 minutes, I suppose that's okay. But I would rather prioritize more writing time, right, than more organizational time. And I say that from experience because a lot of students I know would rather do the opposite. It's easier to plan, it's safer to plan, but if you don't give your time to get anything written down, again, it's at your disadvantage because you're only going to be judged by what you can communicate with somebody, not your understanding, not your outlining, not anything else. And so, here's my suggestion. Hear me out, right? Once you know what you're doing and you know your purpose, consider the idea of briefly reading the facts ever so quickly, right? Like the idea of a minute or 2 minutes, skimming it as quick as possible. I will be perfectly honest with you. I would just read the first page of the facts section, get a general understanding of what you're doing, and really spend more time with the law library. Now, the reason why I suggest that is that legal writing is dependent on the law, right? IRAC writing is good rules, application that follows the rules. Whether it's CREAC, whether it's IRAC, however you do it, that writing is that the law blazes the path, the application section walks the path. And so, because in order to facilitate that symmetry, the facts are only relevant, right? Again, hear me out. When you know why they're relevant. Like the thing I would try to avoid is that you're reading all of the facts, you have a really good idea of what happened, and then you read the law, and the law becomes secondary to the facts because you're focused on things that maybe aren't super relevant. I think of it more along the idea is the facts only matter when you know what the law tells you that the facts matter. When we talk about a marriage being valid, I have a pretty good idea of what I'm doing. I'm going to go over the facts in just a little bit, and I mean the law at least a little bit, and just kind of show you some priority and some things that I'm looking for. But the main thing when it comes to the law is having an approach of saying, know the law first, then give yourself greater time to go over the facts so that your first impression of the facts is just what's relevant. Now, again, you can practice, you can do whatever you'd like, but for me, I am a minute to 30 seconds on the facts for the first time. That way, later, I can spend the 10 to 15 minutes in the facts, really focus on the things that I want, and isolate the things that matter the most more than anything. Now, when it comes to rule development, this is my favorite slide. It's the slide that I use in all of my classes, and I think it's the most important thing that I think you can cover, right? I've done a lot of PTs, I've done a lot of essay writing. Again, I work in the bar office. To me, what I think I see most with with exam writing that I wish I could correct immediately is rule development, right? The idea that students focus so much on the conclusion, they want to tell the story over again, and they minimize the law and the problem to such a degree that it doesn't distinguish the fact that you can be a lawyer. It's just that you can read it and you can isolate where the problems are, and I don't think that facilitates or shows practical legal ability. Good rule statements to me have a collection of these three things, and what I think is in the same order, meaning that I like to start my rule paragraphs with broad statements of the law, right? Tell me the rule, give me the exceptions, give me the definitions, give me the broad statements, tell me what it's about. Then I want you to get into the practical ways to prove the law. Find little elements of rule components that go over like what do they mean? How do you actually win? What are the definitions of the words that ultimately matter in the context of the problem that really matters? I'm giving myself away a little bit, but I often think like statutes are good broad statements. The statutory stuff in the PT are the kind of things where I'm using that as topic sentences, that I'm using the rules from the cases to elaborate them on a little bit more. These PTs are chock full of legal relevant information that often go unused. And so I think that it's like some pretty low hanging fruit when it comes to building those rule paragraphs, but you have to approach the MPT of not, you know, if you're lost in how you're writing, to me, this is where I start. I finally am going to include at the very end paragraph, at the end of my paragraph, a case illustration. Now, case illustrations are best effectuated as the tip of the spear. And what I mean by that is that a case illustration takes the rules that you've used previously and gives you a case that shows you how to use that law in practice. This is what this case says is reasonable, for the point of the law. And your language should not be using the language of the case, but it should be the kind of thing where what you're doing is you're kind of using the case to illustrate a point, right? This is what this means in the context of this problem. You want to avoid things that I like to call book report law. You're just telling me what happened and you're telling me the conclusion, and then you're like, oh, this is the same thing. That's not what they want, right? They want a case illustration that really effectuates and explains the law and helps and make sure that it makes sense. Now, when it comes to that, I want to go back to the law library. I want to show you how I would think about my rule development and kind of go over what I think is the approach that I would do in practice, and I'll show you kind of the end at the very end of the presentation. So I'm going to start from the very beginning of the law library. I'm going to cover a few things that I think are important. And again, you know, there'll come a time to read this all later. So I'm going to go through this a little bit quickly. Let me zoom out a little bit so you can see the whole screen here. But I want to point out a few things, right? The first thing that you're seeing at the very beginning is there's language about parental consent and being a minor, right? To me, this has to be relevant to the problem, right? I mean, I feel like I look at this and I say, all right, this has got to be point one, right? You also have 309, which talks about common law marriage. Again, feels like something that's probably pretty relevant. And then the very end, they're talking about a void marriage when somebody's already married. At this point, I have a pretty good inclination, and I feel like from many years of experience doing PTs, that this is probably the three main points that I'm going to have to talk about. I'm going to have to talk about marriage to a minor when there's probably no parental consent, which is my guess at this point, whether there's a common law marriage and whether or not the marriage is void and what are the implications. And so for me, what I'm going to start with is a topic sentence from each of these. This is what it means to be is when a marriage is void due to someone being underage and the parental consent. This is what it means to be common law married. This is what the prohibited marriage is when someone's already married. So, there's an outline component where you can sort of structure your answer. For me personally, I like to just start writing from the very beginning. I hate when people hate's a strong word, but you get my point. When you take like 10 minutes outlining, but then that outline doesn't translate immediately to what you're writing later on. So I would encourage you to think about the outline of like, can you make the outline more of a paragraph? Because I think that can be helpful sort of at the end of the day. Here you have Hager versus Hager. This is a case that very particularly talks about what it means to have a void marriage and what it means when someone is married during the marriage, right? Now, I'm going to note a few things. Can I highlight this? I can highlight this. When it comes to the law, most cases are organized this way, and I do think that they're trying to capitalize on a certain point. These three paragraphs are talking about, um, you know, what happened. What happened. Particularly the first two paragraphs are factual and procedural circumstances. I'm not saying ignore this part, but remember the fact that rule development comes from the description of the rule itself, not from what happened in Hager versus Hager, which again is not a real case. To me, I think like this to me is an important sentence that I really want to have happen, right? A void marriage is one that has no effect. Notwithstanding 301, it cannot be ratified. A person who engaged in such marriage may be subject to criminal prosecution. Those are the type of rules that I want to take and I want to use to build the rule paragraph. That prohibited marriage section right here, right? A prohibited marriage is void, cannot be ratified. That feels like it makes sense. Even here, right? It can confer no legal rights. It is if no marriage had been performed, it's void and cannot support an action for divorce. Those to me are just the most important pieces of language that I'm going to start thinking about when I'm going over Hager versus Hager. What happened in the original factual circumstance, to me, it's not quite a red herring, but it's the kind of thing that I just want to point out isn't quite as relevant as I think the rules from later on. When it comes to a case illustration, I also want to note this point here. They're talking about the idea of the one party's arguing, well, my husband ratified it. We didn't know that he was married. I think it's voidable. But this court's saying, nope, doesn't matter. It's prohibited. It's void. It doesn't matter what. So my case illustration, and this is the challenge that I would often have with you when it comes to writing about the cases, is can you tell me about it without using the language? For me, it's a matter of saying something along the lines of like, well, in Hager, the court held that even though it was ratified and even if the parties were not at fault, it's still void no matter what. The reason why that matters, why that's the tip of the spear, is it's noting there are no exceptions. It's a hard and fast rule. We don't change it no matter what. That helps me analyze the problem more than talking about, Shirley and Landon Hager, fake people that don't exist. right? We also have Owen versus Watts, which talks a lot about common law marriage. It's a little bit more depth, there's a lot more circumstances. But the point that I want to note also is that you've got this paragraph right here. Under Franklin law, a common law marriage requires agreement by parties legally capable of entering into a valid marriage that they have a marriage relationship. Cohabitation continued after the removal of a legal impediment cannot ripen into common law marriage unless it was pursuant to a mutual consent or agreement to be married after the removal of the barrier. Now, a few things. That's the rule, right? That's the rule you want. That a common law marriage that has cohabitation after the removal of a legal impediment, right, can only make it common law if it's pursuant to mutual consent and agreement to be married after the removal of the barrier, right? So, presumably, I don't mean to give it away and spoil everything, if you're married at the time that you're married and then later you're divorced and then you again that's sort of when the clock begins, that to me is a lot more relevant than again knowing about Owen and McCall, right? We want to make sure that we kind of have a good idea of what we're looking for. And so I just want to point out the idea of like what I am focusing on here more than anything else is the description of what's common law marriage, how do I put them together? That's the priority first. What are the rules and what are the explanations? I'm also kind of getting, whenever I can, the idea of what does the case say about the problem and how do I turn that into a case illustration? Like this paragraph right here. Owen's testimony established at most he and McCall had, by the end of her life, agreed to be married at an unspecified future time. This is insufficient to establish the existence of a common law marriage under Franklin law. To me, this is what doesn't qualify as a common law marriage. A vague, loose understanding to be married later, but not something that's confirmed now. Now, I'll note, you can use that positively or negatively. If we haven't looked at the facts yet, we could look at that and say, well, if we're like that, then great. But if our people have a deep, long-lasting agreement and certification that they want to be married, well, hey, we're nothing like this case, and therefore our people are married, right? So I just want to prioritize the idea of yes, these are cases that you use, but note why you're using them within the time period that you're allowed to use them. I recognize the idea that when you read cases, the more interesting component is always the factual circumstances of what happened. But I think as you're continuing to do this, I want you to think about the idea of prioritize the rule first, the construction of the rule first, and then kind of go over, why and the how and the holding secondary to make sure the priorities on the rules first. I want to take a second or two and talk a little bit of the facts section really quick to know what it is you're looking for and why you're looking for it. One of the things that we talked about before, so we mentioned the idea that we have three main issues we're going to talk about, right? Avoid marriage when someone's married, right? The minority of age, right? Consideration, consent with parents, things like that. And then we're also going to talk about when common law marriage is established. Each of those rules dictates what we're looking for in the facts, right? Like if we're talking before that point that I really focused on, right? What we want to make sure from that last case is that when a legal impediment is removed, right, a mutual agreement after the fact can start the clock on a common law marriage. Well, now I'm looking for the facts and I'm looking for when's a legal impediment removed? Is there mutual agreement? That's what proves it, right? We talked before about the idea that Owen, it was proven not to be a common law marriage because there was an unspecified, vague understanding we'll be married later, not now. Well, is that true here or is that not true here? And so one of the things I want to do about the facts section is I want you to start connecting the dots with the facts, right? This is the rule. This is what I'm looking for. Because again, as I have here on the slide, you don't know what's important till you know what the law requires that it's important. So I want to make sure that in all instances, I want you to get a good idea of like what are the parameters of the assignment. So again, you can judge how much of the facts you want to look into, but I tend to think that like having an eye for what facts are relevant is important because it lets you know kind of what's worth noting and putting your attention on, and maybe what's a little less worth putting attention on if once you know what the law is. Okay, so when we go over the facts section, a few things I want to note. Again, I'm not going to go through this like the greatest level of detail just to be specific, but I want to note a few things that I think are important to note and some things that I think will jump out at you when we're kind of covering a few different points, right? So first off, I want to note the idea that this goes over the marriage and it covers a few things that I think are relevant. She's 17 years old, right, against the wishes of her parents. Um, what else do we also have here? Parents would not consent to the marriage. So we know that that first statute is violated. That's an easy conclusion. We know the law, we know the relevance, we include it, we're good, right? We're also noting the idea that it says, where are we here? There's a point here, right here. All right. Jennifer found in Robert's dresser drawer a copy of a divorce decree that granted a divorce. Never heard of her before, no knowledge he'd been previously married. When confronted, he claimed not to bother her. We also know the fact that there's a marriage at some point that's affecting it, that's bringing up the void marriage. That's, again, where that relevancy comes from. Now, again, does it matter that they knew? No. Does it matter? Um, what was the other point that mattered? Just these the ratification doesn't matter, right? So the point that we're noticing here is like we can put attention on what really matters and we can sort of dispose of some of the things that are a little less relevant. And then finally, when it comes to common law marriage, there's all these points about having kids, being employed, contributing financially to the household. Those are the things that are relevant, the things that you really want to make sure that you're including. I will note the idea that here in May 2020, Jennifer learned that Robert had been having an affair with a coworker that lent the woman $10,000. That's the kind of thing where if you don't know what the law is looking for, you might be like, well, that seems important. But we kind of know from the law that it isn't really important. Him having an affair later doesn't really affect the validity of the marriage at the time. So it just sort of allows you to pinpoint, what's embellishing the story, what really matters. This is a story from a neighbor. I often will also note that, like, the things here are here for a reason, right? They're here because they want to make sure that when you're looking at something, you're you're grabbing something that really seems to matter. This would be the point that I think is most important here. Do they specifically refer to themselves as husband and wife? Yes, always. And in fact, at their anniversary party, Robert gave a toast saying that marrying Jennifer was the smartest thing he'd ever done. That shows mutual agreement to be married, recognition, holding yourself out. That's the fact that you need to do as many things as possible to make sure that that's the fact that matters here. You obviously also have certificates of marriage. We want to note dates. That's probably here for a reason. And then you're also noting this date here, right? You've got the divorce on 2018, right? And you have this, it was just 2013. You'll also note up here that they're breaking up in 2020. So you have a little bit of time period here, just a few dates that you want to note for the requirements when it comes to the rule. But these are the things that you want to check out. When I see stuff like this here, certificate of marriage and judgment of divorce, why is it here? You know, when there's timing considerations, check the dates. When there's location requirements, check the places. These are the type of things that they want to make sure that you have a good eye on, so you know where the rules apply and you make sure you're using them in the correct way. So now that we've got everything planned, that's the easy part, right? Well, the hardest part is probably writing. I find again that for me, writing is easiest when I write the exact same way all the time. I think of myself as a very mechanical writer. I try to write sentences in a consistent manner, which I'll show you in a quick second. But the idea is that, like, I want to make sure that it's organized and it's consistent and it's clear, right? Legal writing is at its best when it seems effortless and easy to read, right? That's the point. What's most persuasive is something that someone doesn't have to kind of squint to see where the answers are. So I have some conclusions that I think are relevant. I'll show you how I put them into practice. First, vigilant CREAC form, meaning that no matter what, that you have clear rule paragraphs and application paragraphs with purpose. So the idea is, like, try not to have standalone paragraphs that don't matter anywhere. Try to avoid telling me the story where there's no analysis, there's no point. That all of your rules are in one place, all your application is in another place, and that they're symmetrical in between the two. Paragraph structure is something that I see a lot on bar exams, and I know it might seem like a throwaway thing, but, like, avoiding one sentence paragraphs, avoid bullet points, avoid bouncing back and forth between the law and the facts. To me, how I write this is I write all my rules first, then I write all the application section second, and I make sure there's that clear division. When it comes to conclusions, everything needs rules and applications, right? Everything needs rules and rule application to make sure that it's included. Everything that you write needs a rule paragraph that precedes it, and to make sure that rule paragraph isn't just telling me what happened in a case, but is focused on the rules and instructively how the rules are put together. making sure every paragraph has strong, clear topic sentences that are your conclusion or the starting point of the law, and then making sure that it's analysis over storytelling. Don't tell me what happened. I know what happened. I don't need to know what happened. What I need to know is that common law marriage is proven because blank, right? They held themselves out in a mutual agreement because blank. Those are the types of things that are there. You want to avoid things that I like to call conclusion sandwiches. You start the first paragraph with the conclusion, you tell me objectively what happened, and then you give me the last conclusion. Again, with the idea that you're assuming that I can connect the dots for you. I want you to connect the dots for me. To me, that's like if I go to a diner and they're like, hey, here's the sugar, here's the flour, here's the eggs, griddles in the back. Good luck making pancakes. It's like, no, no, dude, I'm here so you're making them for me. That's what I want your legal writing to be. Write legal writing like you have to do all the work because that's what makes your writing persuasive. That's what makes your writing good. So let me show you an example of what I mean by that. I'm just going to break it down. Again, I'm not about substance. If you agree with me, great. I think I'm right, right? But I want you to think about your writing and be like, does mine look like his? I make this joke in all my classes, and so if our paths have crossed before, and you've heard this joke. I've always found that, like, I love this expression where if you want to learn a new skill, you copy somebody else, right? Like if you want to learn the guitar and you love John Mayer, right? The idea is that if you copy John Mayer as you're learning guitar, you will go from copying to being influenced once you develop your style and you have an idea what you're doing, right? That makes sense. Now listen, now listen. I'm not saying I'm the John Mayer of legal writing, right? But if you need someone to be influenced by, if you need someone to copy, well, copy the samples that I have, write like mine or write like anybody's that you see, your professor or anyone, and that'll sort of get you to where you need to be so your structure's there, especially if you're having issues with structure and organization and saying, well, I don't know how I can do it my way. Copy someone else's style. Don't copy their content, but you can plagiarize style and figure out kind of how that goes from there to get you to spot where you really want to be. All right, now this is my sample answer. One again, I want to note, I'm not going over substance here. I'm going over form and the structural points that I noticed before. First off, I'm going to note the idea that I'm separating the age issue, the previous marriage issue, and the common law marriage issue separately to make sure that every individual point has their own rule and application section. I don't want to blend them together. I don't want this to be like, lasagna, right? Where we're, sauce, egg, cheese, meat, all of things over. I don't want to mix age, marriage issue, common law marriage over and over again. Clarity comes from simple, easy conclusions. And so you can see my conclusion right here. Jennifer's marriage is void at the time of the age, at her time of her age during marriage. Under Franklin, here, Jennifer's marriage violates family code. Here, Jennifer can prove the parties had a common law marriage under Franklin law. So every one of those paragraphs gives you my answer so you know what I'm looking for. You'll also see here, I have a clear section of rules that are objectively describing the rule. They are then followed by a comparable, for the most part in length and substance, application section that's focused on analysis, right? She was not of legal age because, to me, that's a key point. She may argue she was pregnant at the time of the marriage, but. So there's a qualification with these points where every point of the rule from the beginning is being addressed in the paragraph later on. That to me is key. It's symmetry, right? This law, if there's points in the law, I want to address them later on. You notice the same thing here. I'm giving a description where I'm not just telling you what happened, right? But I'm telling you what happened and why the law matters. He was married at the time of his marriage, which renders the marriage void ab initio, right? So that to me is the key. Same thing here with the common law marriage components. You can see it's a more substantive rule, therefore it's a more substantive application. To me, I think that the point that I struggle with the most is the organization of like how this made sense most importantly. You'll get a copy of this a little bit later, but to me the structure was still sticking with all the rules and then giving the comparable facts later on to make sure that all these points are clear. And so this is something that, again, I wrote in 60 minutes. Is it the greatest writing I've ever done? I like to really pour over my writing. When I write something, I read it out loud. I toil over sentences. So yeah, I don't think this is the greatest writing I have, but when I have to do things under a limited time period, my priority is a clear rule paragraph and an application that is analytical and gives me the comparison points that I need to support my answer in a way that a lawyer would ultimately do it. So that is the next gen PT. Key things I want to note here: practice makes perfect. Truthfully, right? It's the kind of thing where the first time you do it, I think you're going to panic. I still do. I work in the bar pass offices, and when I see these and then I set the timing, I'm like, oh god, So it's the kind of thing where it's not supposed to be super easy, right? I think if you do a PT and you're like, oh yeah, that was a breeze, consider whether you've done it with the right amount of substance. You should be really bumping up against the 60 minutes to give the rules and give the application to cover every single possible issue that you can really do. Now, again, my name's Professor Brett Bendistis. I work in the Bar Pass office. So again, if you're a 1L student, our paths will cross. I promise you at some point. But if you have any questions ahead of time, you can email me over here, right? That's where I am. That's where I'm happy to answer any emails. We can talk whenever you want. You can also put my name into YouTube. Along with this video, you'll see other videos about bar pass work. I have a five five lecture series on Blue Book citations. Did it last spring break. It was a wonderful way to spend spring break. And I also do a podcast on the United States Supreme Court, which has nothing to do with anything. But if, again, it's the kind of thing where you want to know more, these are the type of things that I like to do with my free time. I'm very interested in the academic pursuit of the law. Key thing being this is hard, it's not impossible. With a little bit of time and a little bit of practice and a plan, just like everything, right? That's how things come together. That's how things work. I thank you for your time and attention. I do appreciate it. Again, if you have any questions, you can always email me, and good luck with everything.